Okay, so I'm going to start again. This is lecture number 3 on legal capacity, and I've based this lecture today on a presentation I gave last year in, not last year, last week in Seoul. I'm going to start my screen sharing. And I'm aware that 2 of you who are listening now live were at that presentation in the symposium, so you're going to be hearing it essentially the same or very close, and I apologize for that. Last semester or last spring in this class, I had prepared a presentation on legal capacity that was in many ways more informal and trying to get at some of the questions of and some of the experience about legal capacity. Experience, what does it mean to see oneself in relation to legal capacity if you have been treated as someone whose autonomy is not to be respected by others, who doesn't have a legal right to have your autonomy respected by others, if that has been called into question. And I may bring some of those elements in to the lecture, even though it's more, I guess, technical or impersonal. And I would invite everyone to consider how legal capacity has affected you in your own life, and how that affects the way you want to deal with legal capacity as an aspect of the legal system, as a right under the CRPD. Do you feel that you wish it would just go away? Do you think of legal capacity as something that's part of a legal system and a state that is based on a concept of the individual as, in some sense, a creation of the state, which is really kind of problematic? And that's part of where I go with it for myself and my experience. It's problematic, but nevertheless, so long as we are living within state societies, and where states are the structure for our legal and political system, we have to deal with legal capacity as a kind of legal institution, and a vehicle, a necessary vehicle, and a necessary preliminary right, a necessary fundamental right, that if we don't have that and fight for that, we are not going to be able to exercise any other right. So I see it as a kind of contingent thing to fight for. It's not I see it's an inherent right, it's a fundamental right to have other people respect my autonomy, to have other people respect that I'm an independent person, and I'm an independent organism, that as an organism, as a human being, I am worthy of respect in and of myself, and am not to be used as an object for others' convenience, not to be trampled on, not to have my will, and my self-defense and my self-seeking within a community, and my disrespect. So you'll see there's individualistic aspects that we have to deal with. How and when do we limit our individual exercise of autonomy? I think many of us might have the sense that the individualistic self-seeking of capitalism certainly has to be limited, if not dismantled. And yet, how do we separate that from the desire, and I believe the right, that all of us must have as human beings to be able to defend ourselves personally, to be able to exercise some autonomy in the world, and to be able to say that the standard is that we all have to have these rights on an equal basis. That's essentially the approach that we're taking in the CRPD, and that people with disabilities, people with actual or perceived disabilities, need to have these rights associated with legal capacity, need to be recognized as having legal capacity and all the rights associated with it on an equal basis with others. So let us see if this will actually work well, to do this lecture as a way of introducing people in this course to legal capacity. So from the CRPD, we start out with understanding legal capacity as a human right. Different elements of that: we start out with equal recognition before the law. That includes the status of the person as a holder of rights and duties, an actor whose personal autonomy is protected. So equal recognition is essentially what we're seeing. Equal recognition before the law is what we're seeing in paragraph 1 of Article 12, where simply states parties reaffirm that persons with disabilities have the right to recognition everywhere as persons before the law. That's very basic. It's in it's essentially, it's recognized in the Universal Declaration of Human Rights and in the International Covenant on Civil and Political Rights. When we were drafting the CRPD, the point was raised that we need to use the word reaffirm here rather than recognize, because if we use the word recognize that persons with disabilities have the right to recognition as persons before the law, it would appear as if it hadn't been recognized before, as if this was a new recognition, as if people with disabilities had not been recognized as persons before the law under the Universal Declaration and the International Covenant on Civil and Political Rights. So, although in a sense the language is weak, it could be treated as weaker to say reaffirm. It's more preambular kind of language. It's not an operational language so much. The reason for it is that it was believed that it was necessary to preserve the fact that people with disabilities have already been recognized as having the right to recognition as persons in the previous human rights instruments. So this is essentially the really basic aspect of being recognized as persons who have a worth and dignity equal to those of others. And we see in Article 3 general principles, well, we have, the independence of persons and respect for inherent dignity aspects of 3A. So then we go to, we set this out, the recognition as persons before the law, as the basis, the existing human right that people with disabilities are to enjoy on an equal basis with others, the right to be recognized everywhere as persons before the law, for purposes of the law. the right to enjoy legal capacity is treated as an aspect of the right to personhood. So paragraph 2 of Article 12 goes on that states parties shall recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. Now, this paragraph corresponds to the respect for individual autonomy, including the freedom to make one's own choices, and also to some degree the independence of persons in Article 3A. It also draws on and corresponds to the recognition of in CEDAW, the Convention on Elimination of Discrimination Against Women, that women enjoy a legal capacity equal to that of men. So, here I'm skipping around some, but as I'm describing in this presentation, in CEDAW Article 15, that was the first mention in international human rights law of the concept of legal capacity per se, where it said that states parties shall accord to women in civil matters a legal capacity identical to that of men and the opportunity to exercise that capacity. So we have in the CRPD, we have a similar structure, that the recognition that persons with disabilities enjoy legal capacity on an equal basis with others. And the CRPD guarantee of legal capacity is wider than CEDAW because in CEDAW it was said to be restricted to civil matters, and in CRPD it is see here in CEDAW it says in civil matters. In CRPD it is a sorry, I'm skipping around in the slides, but in CRPD it is in all aspects of life. And for some of us in the advocacy, that has been significant because we see the treatment of people with disabilities in the criminal justice system, the concept that a person could be treated as incapable of being held criminally responsible for wrongdoing is also problematic from the perspective of legal capacity. And so in any case, the general way of phrasing it in CRPD is broader. I will say that the CRPD committee has not spoken on whether criminal declaration of incapacity to be held criminally responsible violates Article 12. They have addressed it under Article 14, which we'll discuss next time. But in the concept and some of the advocacy that has been done around it, and the OHCHR, the Office of the High Commissioner for Human Rights, in one of its reports did recognize this as an aspect of Article 12 legal capacity. So legal capacity as a human right starts with recognition before the law as a person, and it goes on to include legal capacity as holding rights and duties and having the power to act within the framework of legal permissions and prohibitions. So if the law entitles a person recognized as such by the law to make contracts, that's kind of the typical paradigm, then if you're a person with a disability, you have a right to be recognized as a person who has the power to make contracts on the same basis with others. So you have also the same power to get married to another person who exercises their consent to marry you. That's a mutual consent, I suppose, similar to the paradigm of contract. You have the power to exercise the right to free and informed consent in healthcare, to have the final complete say about whether you will or will not accept a particular medical treatment or intervention. The doctor, it's in a sense, it can be seen as part of the contract paradigm. You're contracting with the doctor to perform this, but it's really more of an acceptance of the risk. The doctor is not necessarily agreeing to give you anything in return for your acceptance of the risk, only that their willingness to do it. But it's saying, I understand this, any medical procedure may have certain risks, and I accept them. That's part of it, but it's also simply, it also relates to, in free and informed consent, there's a more positive aspect, the right to have all the information provided to you, and so that you are enabled to actually make a decision that is meaningful to you, and that generally is ensuring that it reflects your actual choice in the matter, and not just a kind of, and that choice, this reflects the sense that choice should be deliberate and well informed, to the extent that the person is, to the extent that the person is in a position to take advantage of that opportunity. So it entails equal powers compared with others in private and public aspects of life. Public aspects of life being citizenship, such as the right to vote, the right to serve as a member of a jury, that sort of thing, which may also be obligations. And it's also a basis for respect, coming away from the purely legal level. The fact that I have legal capacity on an equal basis with others as an adult is a basis for relationships that at least start from a standpoint of understanding each of us may have legal recourse against the other if there are significant wrongs done, rather than, if I didn't have the right to legal capacity, then my relationships with other adults would be colored by that, and would diminish the sense that we're equals, that each of us may have claims and defenses against the other. And I think it's difficult to talk about in a way, because we don't usually want our relationships with other people to be thought of in terms of, I can sue you if you do something wrong against me. But I think in the legal system, at least in my country, I think the United States is a very legalistic culture. I think that this is part of the way we think of what it means to be an adult, in a way that's not necessarily constructive or helpful, but that nevertheless, if it's there, it's detrimental to any person to not actually be included on that on an equal basis with others. Okay, so the right to legal capacity in the CRPD is actually broader than simply thinking of it as a right to make contract, a right to sue someone who wrongs you, a right to make your legal defense if someone sues you and you believe that it's unfair, or simply, even if you don't believe it's unfair, you still have a right legally to make a defense. In the CRPD, legal capacity is more substantive. The right to legal capacity protects your personal autonomy. So, for instance, in general comment number 1, the CRPD committee has recommended that states work on removing all informal barriers to the exercise of legal capacity as well as the formal barriers. And there's also a wider understanding of legal capacity as right to autonomy, in a sense where your right may be legally or factually taken away, um, by, for instance, by forced treatment in the context of mental health, where it may not be explicitly stated that the forced treatment is being done because they don't recognize you as having the legal capacity to make your decisions. Nevertheless, when they take away your legal capacity to make this decision about your own body on the basis of disability, on the basis on a basis that on the basis of disability, or on a basis that's implicitly entails a judgment that they don't believe that you are exercising good judgment, then this is a violation of your right to legal capacity under the CRPD, because it's a removal of your substantive right to make decisions in all aspects of life. So the right to enjoy legal capacity as a human right under the CRPD is substantive. And I would say that, for instance, even if a state did not recognize that anyone had the right to free and informed consent as a legal right within their own legal system, I think that forced treatment would still be a violation of the right to legal capacity under the CRPD. So there are ways that the human right to legal capacity in the CRPD goes beyond mere equality in whatever a particular legal system recognizes. It does include equality in whatever powers to act and hold rights and duties a particular legal system recognizes, but it also goes beyond that. Okay, so here I have a slide showing the development of the right in international law from the Universal Declaration, International Covenant on Civil and Political Rights, CEDAW, and CRPD Article 12. And I have this slide on the different aspects or components of equality. The separation, not really a separation, but describing the right to equality as having three elements or three components. I don't know what they are, three dimensions. I am aware of it as originating with the CEDAW committee in their general recommendations 25 and 28. It may have originated somewhere else, but this is where I know it has been developed in human rights law. Formal equality is essentially being treated the same as everyone else. So in CEDAW, you have women having an identical legal capacity with men, and in CRPD, people with disabilities have legal capacity on an equal basis with others. Substantive equality requires the state to take positive measures to account for different kinds of diversity, whether in relation to opportunities or actual practical enjoyment of the right. And so in CEDAW, you had equal opportunities to exercise that capacity, where women may not be given, say, equal opportunities to engage in contract negotiation and business formation, even in choosing their marriage partners to this in the same way that men have had. And so I think equal opportunities is very relevant to people with disabilities also, and we should really explore that as a dimension of Article 12 sometime. I don't think it's really explicitly brought out in the general comment, but CRPD also provides, as an aspect of substantive equality, that states must provide access by people with disabilities to the support they may require in exercising that capacity. So, support is not something that should make a person feel diminished. It's not something that should make a person more vulnerable to abuse or more dependent on another person. It shouldn't be something that makes a person less equal to other adults or less in any way take away from the person's the person's legal right and substantive right to enjoy legal capacity. It's something that's provided over and above the formal recognition that, of course, you have the right to exercise legal autonomy the same as everybody else. And if you need and want extra support in making sure that in a practical sense you are able to exercise it in a satisfying way in from your own subjective point of view, in then this if it helps you in reality, and of course it's always in your own point of view, if that you are being provided with support, you want to be provided with support, and the support is working for you and it's helping you in your decision making process to be more effective, to be more certain and confident about your decisions, and that you feel basically good about the way you're getting support and the role played by support in your decision making, then it's a good positive measure for you. Support always has to be has to respect the person's will and preferences. And then we actually get into the next one, transformative. The transformative equality dimension requires states to take measures to combat power inequalities. And so for people with disabilities, I think that this reflexive requirement that, yes, support is a substantive equality measure. It makes it possible for many people with disabilities to exercise legal capacity more effectively, more satisfyingly. Support itself has to be subject to this guideline and safeguard that ensures that the support is respecting the person's will and preferences. So support itself has to respect legal capacity, and that's part of I don't know. I would say that may be part of transformative equality, but there also need to be other structural changes aimed at transforming practices that undermine formal and substantive equality. So I have called for the concept of universal design to be applied as much as possible in creating and recreating, redesigning the way that legal capacity is addressed in domestic law. And I think that the law reform they have proposed in Peru is a good example of that, where it's a redesign of the civil code to articulate everything related to legal capacity as part of the CRPD paradigm of equality and support that respects the person's will and preferences and no substitute decision making. So another aspect of transformative equality for people with disabilities is that states must ensure the recognition of legal capacity and provision of support are not undermined by de facto practices of coercion and substitute decision making. So there has to be a lot of awareness raising, education, perhaps training done so that supporters or would-be supporters are not bringing in old attitudes, and also so that service providers, say in the mental health system or other social services, in healthcare and the judicial system as well, are not bringing in their old attitudes and old practices even into the new framework of legal capacity. Children, according to the Convention on the Rights of the Child and the CRPD, have what in essence is an evolving legal capacity. They are not recognized as having legal capacity in the same way as adults. They do have a right to express their views freely on all matters affecting them, and for their views to be given due weight in accordance with the child's age and maturity. Children with disabilities have an equal right to this evolving capacity on an equal basis with other children, and they have the right to be provided with disability appropriate and age appropriate assistance to realize that right. So this is the recognition of formal equality and substantive equality for children with disabilities compared with other children. The right to have their views be given due weight on an equal basis with other children, to express their views and have their views be given due weight in decisions in matters affecting the child. And that's the formal equality, and the right to be provided with disability appropriate and age appropriate assistance. That corresponds to the right to have access to support in exercising legal capacity. That's in Article 12.3 is really expressed in a way that doesn't differentiate between children and adults. So Article 7, talking about disability and age-appropriate assistance for children, is yet a further application of that right to support in exercising legal capacity to the situation of children. CRPD essentially puts an end to the status of legal incapacity for virtually all purposes. Legal capacity traditionally was not a human right at all. It was a status granted by the state according to its own rules. The state could decide with respect to particular individuals or groups of individuals to say that they have legal capacity or that they are legally incapable, that they have full capacity or partial capacity for some acts but not others. The state could treat legal capacity as a rebuttable presumption. And you need to be careful about this, because when you hear the word presumption, it could mean a rebuttable presumption or an irrebuttable presumption. If someone says about, if a state party representative says, we presume that everyone has legal capacity, that may sound great. It may sound like, yes, we presume it too. The CRPD presumes it, and everybody has it, and you can't take it away. But what's known as a rebuttable presumption means that we presume it, but it's not conclusive. We presume it until, say, your mother or your sibling or your adult child calls your capacity into question, and then we allow a judge to hold a hearing, and the judge may decide that, in fact, you don't have legal capacity. So again, treating legal capacity as a rebuttable presumption is one way of allowing the state to to make its own rules about who some people have legal capacity and some people will not, or will have it taken away from them. CEDAW limits states' prerogative so that they can no longer discriminate based on sex in according legal capacity. And CEDAW jurisprudence discusses the importance of legal capacity to women's equality, drawing attention to the personal and societal impact of unequal capacity. I think this resonates strongly with people with disabilities, and I think in general, once it was recognized in international human rights law that it's wrong to discriminate based on sex in according legal capacity, and it gave people the opportunity to think about what it means as an experience to be deprived of your legal capacity, that helped certainly to open the door for people with disabilities to argue the same thing, that yes, you see, women with disabilities are women the same as CEDAW. We suffer the same as other women when we're deprived of legal capacity, and so do men with disabilities suffer when they're deprived of their legal capacity. Why should our suffering be treated as any less? And then the CRPD really, so I think CEDAW was moving towards treating legal capacity per se as a human right, the way that the CRPD does, particularly in the CEDAW jurisprudence and its general recommendation number 21, paragraphs 7 through 9, which I remember because we were using it as at a key point in advocacy in the negotiations. So the CRPD further limits states' prerogative to the point of removing most conceivable bases for the restriction of legal capacity. Disability and impairment and incapacity are linked terms and concepts. I think it's very clear now with CEDAW, even though it's violated in some parts of the world, even in a formal equality sense, it's very clear that you can't discriminate based on sex. It would clearly be racial discrimination if a state were to accord different legal capacity based on a person's designation of a particular racial group or ethnicity. Other factors such as, I don't know what, other factors that usually would account for the discrimination, such as religion, political opinion, I cannot see those ever being recognized as legitimate grounds in human rights law to deprive someone of legal capacity. So legal capacity, at the least, has to be without discrimination. And with the one caveat, so far we do have different legal capacity for children compared with adults. And I will say just parenthetically on that there has been some very informal discussion about the question of whether the CRPD paradigm of understanding legal capacity could be extended to children, where the support provided to children would also include a level of guidance that relates to their age and immaturity, their physical as well as, I suppose, intellectual and psychic immaturity. Without wanting to get into any more detail about that, just flag as as something to be explored. But at this point, age in the sense of childhood is still a ground for treating a person as having different or less legal capacity. But in most states, in the modern states' laws, in the most modernized of states' laws that still accept an incapacity framework that say people can be deprived of legal capacity. Some people may not have legal capacity. We treat it as a rebuttable presumption. We will have the least restrictive alternative. In any of these, in all of these states, in all of these most modernized laws that still recognize incapacity, it's linked to the concept of actual or perceived impairment, actual or perceived disability. And in essence, it's related to actual or perceived mental impairment, whether intellectual or psychosocial, cognitive, however we may describe different aspects of that, it's always linked to a concept of mental impairment. And in some laws, that's actually made explicit. So I think it's very justified that to say that the CRPD, by saying that disability, including any actual or perceived impairment, can no longer be a legitimate basis for depriving someone of legal capacity or restricting their legal capacity. The CRPD does put an end to the legitimacy of treating anyone as incapable. So even the most modernized laws that treat people as incapable, that allow the state to restrict legal capacity, because these bases are all related to disability, except for the part about how they deal with children, the CRPD virtually puts an end to the status of incapacity, requires states to put an end to that status of incapacity. Besides children, only, according to the CRPD committee, only restrictions that have no linkage to actual or perceived disability, impairment, or mental capacity might be permitted. That exact wording is mine. It's not theirs. They say only restrictions that do not discriminate based on disability might be permitted, and they give the example in the general comment that some states restrict a person's capacity after criminal conviction or bankruptcy. And I would say two things. I would wonder whether further exploration would show there might be some implicit sense that a person may have a form of disability or impairment, a suggestion that bankruptcy might be perceived as relating to some kind of impairment, but it may not. I think for me, a deeper issue that I would question here is whether, given the way that both CEDAW jurisprudence and the CRPD jurisprudence are describing the very detrimental effects of being deprived of legal capacity and treating legal capacity as a fundamental right, whether these kind of grounds as a kind of punishment or some kind of, I don't know really what is the reasoning for these restrictions of legal capacity, whether any of that really still should be whether that can stand up to our understanding of legal capacity as a fundamental human right. So, as I think many of us already know, this is according to the general comment, the term capacity, or this is based on the general comment, the term capacity has been used to conflate two concepts: legal capacity, which is the legal doctrine by which persons are recognized as rights holders and legal actors, and the concept of mental capacity, to refer to the actual or perceived decision-making skills of an individual, which the CRPD committee says is a problematic concept contingent on social and political contexts. And as we know, Article 12 prohibits the deprivation of legal capacity based on a person's actual or perceived mental capacity. So I think that, it's in a sense, it's a single term. Is it a single? In many ways, I think that it's simply two different meanings of one term that are conflated and that don't necessarily have anything to do with each other. And I've given the example of capacity in the legal sense as a kind of, it's simply a recognition of legal power. And it's similar to saying that, to asking whether a particular court is competent to hear a certain case. So we're not meaning whether the judge has good judicial skills. We're asking whether the court has an actual mandate to hear this case. If I go into criminal court and I want to bring a claim for a contract, that's not going to be the appropriate place. The court will not be competent to hear that claim. I have to go to the court will only be competent to hear criminal cases. And in the same way, the sense of legal capacity is a similar kind of legally recognized power. What is the scope of my legally recognized power to act autonomously? It's not a question of whether I have good or bad skills, and usually we don't really ask whether the person has good or bad skills, only because we're conflating it with this concept of mental capacity or decision-making capacity, where we might ask, why do we even think about people in that way? Why do we even, in any case, start looking at what people's decision-making skills are or might be? And that's the whole. Then we get to issues of many different kinds of discrimination, and also we get to issues of legitimate concern for the unfairness and exploitation involved in the individualistic assumptions about legal capacity, the assumption in contracts that every party is equal and nobody has an obligation to look out for the other one. You're just, as the sexist phrase would say, every man for himself, and you're supposed to take care of yourself. And, many people with disabilities, because of reasons related to their disabilities, may be less able to take care of themselves in that individualistic way. And then we talk about bringing in support, and in the CRPD paradigm, support is still going to be about respecting the person's will and preferences. Support is not going to be a paternalistic assumption that somebody else simply is going to support you by doing it for you or because they know better. So this is different approaches that have been used to take away legal capacity: status-based, outcome, and functional. I won't go into that, just leave it there for you. This is essentially similar to what I've been saying about the concept of disability, impairment, and incapacity, or denial of legal capacity based on actual or perceived decision-making skill, is discriminatory. Those concepts are related, and under the CRPD, under the general comment, all of those approaches, any approach to any denial of legal capacity based on a person's actual or perceived skill in decision making, is discriminatory based on disability and is a violation of Article 12, according to the general comment. And yeah, I think there's different ways of reasoning about that. So I'd like to go to some aspects of the state party obligations in Article 12. States parties must ensure that their legislative framework. I'm just okay. I'm just trying to think about the aspect. I think I'll just say one more point about support in relation to legal capacity. I think for people with psychosocial disabilities, the issue that is raised with us in relation to legal capacity is more often about other people's sense that we are not exercising good judgment. It's not so much our cognitive skills. It's not so much the question of whether we're going to be abused by others as being less in a position to take care of ourselves. It's more a question that people have an approach or an attitude that they believe we're not going to make good judgments. That is a kind of mistrust of what we might do. And I think that support, in that sense, support is not necessarily going to be the same. And many of us, when we look at the question of support, we end up thinking, I don't need support. I don't want support. Support is not what's going to help me. What I need is maybe for the environment to be a little bit more forgiving of my mistakes. If I need anything for the environment, I may need certain practical support while I'm going through these difficult experiences where I may very well make a lot of mistakes. Or we might say, yes, I do need support, and I really want to work on figuring out what is the kind of support that will work best for me, because it's not going to be the same as, or it may not be the same as what has been worked out for people with intellectual disabilities. So I think between the two communities, there's often been a lot of very good synergy where measures that people with intellectual disabilities find useful, we might look over and say, yes, I think that would work for me too, and vice versa. And then, but there's also a constant kind of dialogue and maybe a dialectical process where we're looking over and saying, well, that really won't work for me. We need to do something different. And then they might say the same about something that we're developing. So I think it's important to just look at some of the differences and the similarities, and also differences and similarities sometimes with respect to whether a group is developing certain supports for themselves or whether they're being developed for that group by others. Some of the measures that have been developed for people with intellectual disabilities may actually be more reflective of the concerns of their parents and other supporters in their lives. And, you know, and they may not be. So I think I think that we also need to develop some of that consciousness in terms of it also has to do with sometimes levels of support people actually need if a person is not communicating in speech or sign language, if they are not using verbal communication, whatever the kind of disability they have, they're going to have certain needs that that probably in that case, you do need to say the person has a support need. There has to be something done to approach that person in order to make it possible for them to be exercising legal capacity in any sense whatsoever, in order to have the relation between themselves and others. So that's going to be different than people who are using verbal communication, and there's a different kind of negotiation already possible. Okay, so now to go to the state party obligations. This is in a few different. I will try to to talk about this in a way that makes it clusters in different areas. So here, I think I'm talking about certain general areas. States parties must ensure that their legislative framework recognizes the legal capacity of persons with disabilities on an equal basis with others, and eliminate any provisions that allow for the removal of legal capacity based on disability or decision-making skills. So this is recognizing, this is the obligation to change their legal framework to reflect what's in the CRPD. The universal recognition of legal capacity for adults, no removal of capacity based on disability or based on decision-making skills. States parties must eliminate substitute decision-making regimes such as guardianship and mental health laws that allow detention and forced treatment. Now, the general comment includes both of those. The general comment includes mental health laws as a form of substitute decision-making regime that states parties have to eliminate. And I would strongly advocate that legal capacity reforms include this dimension. Otherwise, if they don't, people with psychosocial disabilities are going to be burdened and disabled and handicapped by this extra regime that deprives us of our substantive right to exercise legal capacity, and sometimes very explicitly deprives us of the legal capacity to make very important decisions about our physical and mental integrity. So that's the next obligation, that they must not just simply recognize in principle that we all have legal capacity, but they must remove all the substitute decision-making regimes. States parties must develop supported decision-making systems that meet the full spectrum of support needs and are based on the will and preferences of the person concerned. That could include some aspects in a legal framework, as well as quite a lot of work in a practical and programmatic and policy framework to ensure that there is a system of supported decision making that's available to everyone who may need it with different kinds of disabilities. Or maybe we're going to, yes, we do have to take account of different kinds of disabilities, and we may not, I think we should not necessarily make self-declaration of disability a requirement to access support. There may be reasons that people may not want to self-declare, or may have needs even though they don't identify as persons with disabilities. States parties must ensure that safeguards against abuse in a system of supported discrimination, in a system of supported decision-making do not discriminate against people with disabilities. So they are obligated to create safeguards against abuse, and they have to make sure that these safeguards don't discriminate. So going to the general comment, that's Article 12. There's a general comment. So they're talking about people being at risk of undue influence, that and this may and this may even be exacerbated for those who rely on the support of others to make decisions. So that's a legitimate concern. Safeguards for the exercise of legal capacity must include protection against undue influence. However, the protection must respect the rights, will, and preferences of the person, including the right to take risks and make mistakes. So the states are obligated to ensure that there are safeguards that are protecting the right to the rights, will, and preferences of people with disabilities. They have to make sure that they aren't, in a sense, I'm not going to use that word really. That they're going to have. They have to make sure that the safeguards are not discriminating, and that people with disabilities are not being put into a situation of being overly safeguarded in their exercise of legal capacity compared with others. In my view, safeguards should be as much as possible universally designed, that there should be safeguards to protect everyone against abuse and exploitation when they're exercising legal capacity, to make sure that it's that no one is exercising undue influence over them, and that would include supporters. And at the same time, if I'm choosing someone to support me, then I am placing my trust in them to an important degree. And in a sense, it just becomes a situation of needing to balance those two things, and always the will and preferences of the person needs to be the central focus and reference point as to any concerns that are being expressed in relation to legal capacity. So just yeah, I think sometimes it's difficult if you're in a situation. I mean, well, I'm just there's an example that I'm thinking of. If someone is needing support to exercise legal capacity, they might be receiving support from a spouse, and let's say a friend of theirs thinks that the person may simply not be telling their spouse everything that there is to say, but they are telling that friend, and the friend may think that they know better what the person actually wants. If there's I think you need to be somewhat careful to not interfere or intervene excessive, to respect the relationships that the person has with these different people. And at the same time, if there's a question raised, the issue to be resolved is what are the will and preferences of the person concerned, not fundamentally what does the spouse want or what does the friend want. That and of course all of those things can end up being difficult. I've put in a few extra things here. What is support and how does support work? In case we want to go into some understanding of how the disability community understands what support is. So I will just read this one. Support means the development of a relation and ways of working together to make it possible for a person to express him or herself and communicate his or her wishes under an agreement of trust and respect reflecting the person's wishes. I will just leave these slides for you to consider for yourselves. They come Yeah, I see I've left something in that I didn't mean to leave in, but these are derived from a presentation from 2006 that I have linked on the course content page for this lecture. I think I'll just continue with the states parties obligations. So to go into a little bit more detail about what it means to establish a supported decision-making system according to the general comment. I'm going to cluster some of these here. Some of the features of a supported decision-making system relate to universal access. So they have to accommodate all levels of need and all modes of communication, including it's not letting me do that, including high support needs and communication understood by very few people. There should be no financial barriers, nominal or low cost. States parties need to facilitate the creation of support for people lacking natural support. Those are the elements that are related to universal access to supported decision making. Then there's the cluster of features that have to do with bringing back in the formal equality aspect of everybody has legal capacity. There's no obligation on the person to use support in order to be recognized as having legal capacity. And, we're transforming the power relations. Support itself is not going to be subject to these power relations where someone is making decisions for the person, someone is saying they know better than the person. So this cluster, we have all support, including intensive support, is based on the will and preferences of the person. There's a right to refuse support and to terminate or change the support relationship at any time. The provision of support cannot be based on mental capacity assessment. It requires the development of new non-discriminatory indicators of support needs. And these indicators could even simply be an interactive conversation, interaction with the person that is always checking back with the person to see how they react to your supposition about what they might need, so that over time, together, you develop an understanding of the person's support needs and what works for them as part of a holistic, integrated process. That's how I would prefer to see support provided. And but what they're talking about here, non-discriminatory indicators that could be understood to allow different kinds of processes. For example, for someone to be making an assessment of your support needs in a more, say, trying to be objective sense or a more professionalized sense. My preference is to do it the interactive way, because that allows the maximum participation by the person who is, presumably or is being offered support, to actually create their own support. So it's the maximum way of having the provision of support reflect the entire substance of Article 12 of exercising legal capacity, exercising autonomy and decision-making in relation to every aspect of providing support, creating a support relationship. And lastly, also in the realm of respecting the person's autonomy, and formal equality here, the use of support does not justify limitation of fundamental rights, such as the right to vote, marriage or civil partnership, intimate relationships, medical decisions, and the right to liberty. That's another feature of the supported decision-making system specified in the general comment. Lastly, there's the question of safeguards as features. So one element they describe is legal recognition of the support person and a mechanism for third parties to challenge the action of the support person if they believe it's contrary to the will and preferences of the person concerned. And then generally the establishment of safeguards to ensure that the person's will and preferences are respected. Now, having legal recognition of the support person, I would maintain that is only relevant in a subset of kinds of support, informal kinds of support, where your supporter is meant to be involved in a way that recognizes them as another actor for purposes of the legal system in your decision-making process. So, for instance, if I am making an advance directive and I want another person to actually be able to act for me in certain situations, advance directive or power of attorney, I'm giving this person the legal power to act on my behalf. I'm not, and setting aside various complications with advance directives for the moment, although maybe I will get back to that. You need to have to execute that as a legal instrument, and for that relationship to be legally recognized. Also, if I want to establish that in certain decisions, say if I'm buying something that's worth more than $1,000, I always want to discuss that with my support person, and I want that any contract I make for such a purchase should need my support person to countersign that they provided me with, or that they should need some participation and recognition of my support person. There you need the legal recognition. There might also be other purposes if someone is receiving very intensive support, such as a person who is not communicating verbally, only communicating non-verbally. Maybe you need to hold the support person to account in a way that requires legal recognition of that relationship. You need to be able to understand who is the person providing such support. But I think that's a question, and it shouldn't be assumed that everything that comes under the framework of supported decision making requires legal recognition. Many of the mechanisms developed by people with psychosocial disabilities that have been characterized as a form of supported decision making either specifically disavow having such a legal element or just don't consider it necessary, such as peer support, various kinds of peer support and peer advocacy, and the personal ombud program in Sweden. I've indicated some additional components of a supported decision-making system. There's the forms of support are described in in addition to those features of the supported decision-making system that I was just in essence outlining and summarizing, that are in paragraph 29 of the general comment. There's also the section, the normative, the section on the normative content of Article 12, paragraph 3, that describes different kinds of support. And as you see, it does encompass both informal and formal support arrangements, as well as it includes peer support, advocacy, or assistance with communication. It may include measures relating to universal design and accessibility. So this is a much broader concept of support that includes systemic and universal design measures and additional programmatic measures beyond what's characterized as the features or essential elements of a supported decision-making system in paragraph 29 of the general comment. And I think it's important that to hold both of them simultaneously, and not that states should not simply use paragraph 29 and as a checklist, and they need to also come back to this normative content, paragraph 17, 18, and 19 in particular, to make sure that they're capturing everything. Here in paragraph 17 is where you're going to find the reference to advanced directives, advanced planning, and in my view, advanced directives, as sometimes in the mental health context and among people with not really among people with psychosocial disabilities, it's more the mental health actors and others who are trying to make policy in relation to people with psychosocial disabilities. Advanced directives is seen as, okay, that's the formal mechanism that people with psychosocial disabilities particularly need in relation to exercise of legal capacity. They might not need an ongoing supported decision-making agreement, but they might need to do these advanced directives and then have somebody else come and represent them essentially when they're in a crisis. I think that that's problematic because there's a lot of assumptions built into that. Often, the way it's described, there's a lot of assumptions built in that an advanced directive is going to operate as essentially substitute decision making. That, say, in an advanced directive, I will write down now, I don't ever want to be given Haldol, I don't ever want to be given electroshock. You know, some person might say, I want to be given such and such a drug. Personally, I would never say I want to be given any psychiatric drug. So I won't even, I say that, but, or I want my friend to take me to such and such a place where I will be able to be in solitude and enjoy quiet and walks in the woods. Let's say I say that in an advanced directive. And then let's say the time comes and I'm finding, gee, that's not what I need at all this time. Maybe that's what I needed in the past, but this time I really need something different. This time I need to go out dancing. And then let's say in a more intrusive way, let's say a person is writing in an advanced directive, my voices are really bothering me. I want to, if I am, saying such and such a thing, it's an indication that my voices are really bothering me and I want to be given a low dose of Haldol. And even if I'm protesting, I want it to be done. Again, what happens if that time comes and the person suddenly realizes, no, what I need is not that. I have this huge insight, and I need something completely different this time. So I think to treat an advanced directive as to make the kind of advanced directive that is allowing a person to do something that's against what your will and preferences are at the time it's going into effect is hugely problematic. And I would really, advocate that it not be done. At the same time, I also am aware that for some people with psychosocial disabilities, the option of, actually allowing that. Are people hearing me? Is there a problem? Oh, I see someone is. Okay. Okay. It's just are you okay? Okay, so it was just what I was hearing is someone leaving. Good night. Thank you for joining till now. And to get back to where we are, let's see. Right. So that about advanced directives, to talk about an advanced directive entering into effect and being put into effect, if it's something that is going to be that is going to allow someone to do something to you against your will at the present time, if it allows someone to take action in relation to you at a future time, even if you're objecting at that future time, I think that's very problematic. I have recommended against it. And at the same time, I understand that for many people with psychosocial disabilities, that allows them that might allow them as at least a transition away from the system of forced treatment if they feel that they're concerned what might happen to them. Um, they want for something to be able to done. They want to have something to be able to be done to stop a process that is frightening and distressing to them, and they're willing to sacrifice the possible loss of autonomy in that situation. And I think in practice, we have to allow it, but not emphasize that, really to emphasize development of other supportive ways of relating to people experiencing extreme distress and altered consciousness that are not necessarily going to be supported decision making as we usually understand it, a particular individualized support relationship, um, but that nevertheless have that serve that same purpose for people with psychosocial disabilities, the purpose of ensuring that in these states of mind that we are able, it's like it's a kind of both emotional support and also support um, to make your decisions as you're making them in the present moment, and maybe have access to having some feedback on those decisions as you're making them to the extent that you want it, and to have some to be able to create the kind of safety that you want for yourself, and not to be and to defend yourself against, not to be subjected, to not be subjected to what other people are afraid of about you or for you. Of course, always knowing, that we have obligations to not harm others. So others' safety limits our autonomy. To the extent that you feel a need to hurt someone else, that has to be limited, and that's not a deprivation of legal capacity. So that I wanted to make that comment on the advanced directives. Also, I want to emphasize here the general comment specifies at all times, including in crisis situations, the individual autonomy and legal and capacity of persons with disabilities to make decisions must be respected, and that some persons with disabilities only seek recognition of their right to legal capacity as provided in paragraph 2 of Article 12 and may not wish to exercise their right to support as provided for in Article 12, paragraph 3. So that specifies that support is going to be provided to augment our exercise of legal capacity, to enhance our exercise of legal capacity if we want it. It can never be imposed on the person to say, you must use support, otherwise we will not recognize your decision making. My decision making has to be recognized, period. And then if I want support to enhance my effectiveness and satisfaction with my decision making, I have a right to that also, in addition to the right to have my decision making respected. Okay, let's go back to here. And I don't know if I will get through all the slides. Let's see what we do get through. Recognizing universal legal capacity. This is another of the key obligations of states parties under Article 12. So how should the state proceed? What should be contained in a state's law reform on legal capacity? The law must recognize the universal legal capacity of adults without limitation and repeal provisions that allow removal of legal capacity based on discriminatory purpose or effect. The manifestation of the individual's will and preferences should be sufficient to constitute a valid exercise of legal capacity. So rather than having any kind of functional test of legal capacity, anything in, say, the law on free and informed consent in healthcare that would say, in order for consent to be considered free and informed, the person has to demonstrate that they understand and appreciate the nature of the treatment, the risks and benefits, and the consequences. You cannot have that kind of requirement for free and informed consent to be valid. You cannot require that the person demonstrate any kind of understanding or appreciation, because that's, in essence, subjecting their judgment, subjecting their decision making to the veto of another person based on the fact that the other person considers their decision making skills to be poor or limited. So the process of, say, soliciting or engaging in free and informed consent in relation to healthcare, it has to place an affirmative burden on the healthcare provider to provide information in a way that the person can understand, from the person's own point of view. It has to provide information in a way that's accessible to the person. If the person is using support, the support person needs to be also has a role. If the healthcare provider is perceiving that the person is having difficulty understanding the information, or with any other aspect of the decision, they need to be able to offer some kind of support, engage in some kind of process to understand what the person's needs are and to work it out. And at the end of the day, the healthcare provider still needs to accept the person's manifestation of will and preferences in relation to that decision. And the healthcare provider still needs to be able to exercise their own professional judgment as to the value of a healthcare intervention. So what I mean is the professional has to be able to exercise their own judgment in a sense that if the professional does not think that a healthcare intervention is going to be, I mean, if I'm going to go to a healthcare professional and say, or say some hypothetical person, you go to a healthcare professional and says, I have a heart condition. I would like to have open heart surgery and have a bypass done. The healthcare professional needs to exercise their professional judgment of diagnosis and decision from their point of view what treatment is appropriate to offer to the person. And then the person has the right to exercise free and informed consent. The professional's judgment does not replace that, but at the same time, so the professional's judgment is also, in a sense, another safeguard against, harmful processes harmful treatments. The person's legal capacity exercise is their decision making, but it's not to say that the healthcare professional has cause to be reckless just because a person may consent to something. That's all I'm trying to say. Sorry. Public and private duty bearers are obligated to provide accessible communication, reasonable accommodation, and access to support when needed in relation to the exercise of legal capacity. When it is genuinely not practicable to determine a person's will and preferences after significant efforts, the best interpretation of will and preferences is to be applied and not best interests, which is inappropriate for adults and amounts to substitute decision-making contrary to Article 12. Now I'm going to say something like all of these elements I'm describing on this slide need to be included in a law reform. I've been amplifying on certain aspects, as I did with manifestation of will and preferences, but in essence, what's on this slide are elements that need to be included in a legal capacity law reform. So the best interpretation of will and preferences, that's probably, I would say, I think I've taken verbatim or nearly so from general comment number 1, paragraph 21 here. And the best interpretation standard or principle is a way of ensuring that the support paradigm of universal adult legal capacity and support that respects the person's will and preferences, that this new paradigm is seamless and is applied in every conceivable situation involving an adult's exercise of legal capacity and decision making. So what do you do in a situation where the person is not communicating? And it's not that it's an intentional non-communication, which is a kind of communication, but the person is in a coma, or the person has been, made medically or physically unconscious from an accident, it's not possible, it's not practicable to determine the person's will and preferences in that situation. And we're specifying after significant efforts have been made. You're not going to make that determination lightly, that it's not practicable to determine their will and preferences. In that situation, you are always going to be aiming for the best interpretation of the person's will and preferences. So that's another a possible role for an advanced directive, to write down, this is what I want in this kind of situation if it should happen in the future, and I'm simply not in a position to be communicating my will and preferences. This is what I would like you to do, as a sort of next best alternative to actual determination of my will and preferences. Or if there is no such writing, then what do my closest loved ones and friends know about what I would want in that kind of a situation? What are my overall values? So for me in particular as a person, people around me would know I do not ever want to take any neuroleptic drug or anything similar in chemical composition for any reason whatsoever. Um, you know, people would know that about me, and that I prefer not to have any strong drugs of any kind. So that's the kind of thing. From people knowing you, you can make a best interpretation as an approximation, getting as close as possible to what the, as I guess as a next best alternative approximation of what would be your best guess as to what the person's will and preferences would be in that situation, given the person's own indications and what people know of this person. So, as Lex Grandia said during the CRPD negotiations, a good friend and colleague who was president of World Federation of the Deafblind at that time, who has passed away now, he gave a very succinct explanation of this. If I'm in a coma and then I start making decisions, I don't want to have to go to court to get my legal capacity back. So instead, I mean, that's one way of understanding what we're doing here. We're not making a kind of mark to say, oh, now the person lacks legal capacity and someone else has to be the substitute decision maker. Instead, it's some kind of process that's about ensuring we're trying to approximate the person's will and preferences as much as possible. And I would say there's always an obligation to keep making the significant efforts, to keep going back and checking. Maybe the person is starting to exercise their legal capacity, and when that happens, we're going to respect their actual will and preferences. We're not going to continue or try to force them to go through some other kind of process to get back the right to be directly, to have their will and preferences respected, because the way that this standard is conceived, it's all within the framework of respecting the person's will and preferences. So of course, when the person reverts to exercising their will and preferences in a way that we can determine, then of course we're going to respect the will and preferences that we now determine. We're not going to be using the best interpretation. And then lastly here, legal capacity and the person's decision-making must be respected at all times, including in crisis situations. I think some ways for that to be reflected in the legal framework would be, for instance, in healthcare decision-making, and to be part of reforms that abolish the detention or involuntary hospitalization and forced treatment in the mental health context. Identifying and eliminating substitute decision-making regimes. In this slide, I just note some of what the CRPD committee has determined as characteristics of substitute decision-making when legal capacity is removed from a person, generally or in respect of one decision. So even in respect of one decision, if your legal capacity is removed, and effectively removed, even if it's not legally stated, by forcing psychiatric treatment on you that you don't want, that's a substitute decision-making regime, according to the general comment. Also, if the substitute decision maker can be appointed by someone other than the person concerned against your will. So that leaves open the possibility that I could appoint a substitute decision maker, or that a court might appoint a substitute decision maker for me if it was something that I was consenting to. I think that's kind of risky, but I think it's certainly clear that appointing, because I think it's risky because of the possibility of undue influence, as well as the inherent risks of appointing any kind of substitute decision maker. But okay, if I want to appoint a substitute decision maker, that's not the same as that may not, if I'm really exercising my free and informed consent, my legal capacity, it won't be considered a substitute decision-making regime. And it's also considered a substitute decision-making if the decision made by a substitute decision maker is based on best interest as opposed to the person's own will and preferences. So maybe the best interpretation standard, would be a kind of substitute decision making understood in one sense, but it won't be characterized as a substitute decision making regime as the kind of substitute decision making regime that has to be eliminated. Also, as I mentioned before, states parties must combat formal and informal substitute decision making. And custodial care arrangements in which care providers are empowered to restrict a person's autonomy according to their determination of the person's care requirements are a kind of substitute decision making and must be abolished. I don't think the general comment doesn't mention this, but I am very concerned about situations such as I've seen in the US in relation to older people, where the person enters into a facility that's said to combine independent living and assisted living, and the facility is always making capacity determinations of their physical capacity and mental capacity, and saying, oh, you can't walk by yourself, you need to go into assisted living, you need to move from this floor to that floor, or can you count backwards from 10? Can you tell me such and such about what's in the news? No. Oh, maybe you lack mental capacity and you have to go to this other place also. There's many problems with those kind of regimes, and obviously, and I would consider that a kind of de facto substitute decision-making regime that needs to be eliminated, and that needs to the extent that it's partaking in legal mechanisms, those legal mechanisms have to be reformed or eliminated, and to the extent that it's just operating as de facto substitute decision making, there needs to be some oversight so that it's obligated to not do that, and yeah, I don't know exactly what that needs to be done, but just flagging as something, another kind of regime that needs to be eliminated, even though it may be to some extent informal with respect to any direct legal authorization for the substitute decision-making aspect. Safeguards. I think I've said safeguards are needed to ensure that supporters, counterparties, and authorities respect the person's will and preferences. Safeguards do not question the person's decisions or decision-making capacity. And I would say that both support and safeguards against abuse depend on the quality of the interaction and an attitude of patience, openness, willingness to interact with and communicate with the person concerned. Note that both the best interpretation standard and this safeguard against undue influence are treated in the section of the general comment dealing with safeguards. And I think I've already discussed both of those. I'll just make a further comment on best interpretation. In a sense, this is thinking of it in terms of epistemology rather than ontology. What can we determine about the person's will and preferences? How can we approximate that best if the usual, if a clear determination, if an accurate determination is not possible, and instead of what is the best thing for the person, does the person have or not have legal capacity? That's kind of like a falsely, I mean, it's a legal fiction in any case, but so we're talking about an intersubjective process, a process of determining based on an interaction what the person's will and preferences are, or if you can't tell that, what is the best approximation to what they might be, rather than falsely objective, saying this person lacks decision-making ability and we are therefore going to decide what is best for that person. Additional considerations for implementation. In addition to systematically reforming the laws on legal capacity, I'm not sure if and eliminating the mental health laws that allow detention and forced treatment, there's a need to review and reform legislation and practices relating to the exercise of legal capacity in all spheres, including access to justice, liberty and security of the person, integrity of the person, privacy, marriage and family relations, right to health, and political participation. Just enumerating certain articles of the CRPD, certain rights that are addressed in the CRPD, where legal capacity may be dealt with in domestic legislation, and the legislation needs to be reformed. Also, as I indicated earlier, it should be done. It hasn't been done yet in legal capacity reforms that I'm aware of, but it should be done, that to consider the obligations of equality and non-discrimination with regard to the responsibility of people with disabilities for breach of their legal duties and liability to criminal and civil penalties. So liability to civil penalties in the sense of, say, breach of contract or an act of negligence, that would seem to me very clearly an outgrowth, a logical corollary, a necessary corollary of having legal capacity is being held responsible for those actions you undertake in the exercise of legal capacity, or as a person who has legal capacity. In the criminal system, I think that the reasoning is also applicable to criminal penalties as well. CRPD, under Article 14, the jurisprudence of the committee calls for the abolition of declarations of unfitness to plead and declarations of incapacity to be held criminally responsible. I will just leave this here for you to read and to be aware of. We will deal with these issues more again next time in the context of Article 14, and can also address it in greater depth on its own if people are interested. We did in the spring, last semester, as an optional lecture in the course. Okay, this slide I think we need to ensure older persons are included in legal capacity reform and in the consultations, and of course ensure close consultation, active involvement of people with disabilities in all these reforms. Okay, I'll indicate briefly there's a controversy, well, of a sort. This is something that I was personally involved in that I'm going to just flag. Eleanor Flynn and Anna Arsting Kerslake, in a paper of theirs, proposed that it would be legitimate to have disability neutral coercive state intervention when a person's life, health, or safety is at imminent risk. This is actually proposed in a paper that's specifically about state intervention in the lives of people with disabilities. So I would actually say that the motivation is suspect from the starting point. Why are you especially concerned to create some mechanism to promote state intervention in the lives of people with disabilities? That's the problem to begin with. But they have proposed that it's possible, that it's legitimate and non-discriminatory if it's framed in a disability-neutral way so as to avoid mention of disability, impairment, capacity, mental health, anything like that. And I very strongly disagree. I would say it's nothing but a functional capacity test in disguise and an application of the best interest principle to adults. I've given you some references you can read if you're interested in that. Law reform, I know we're almost out of time. I have these slides on law reform where Costa Rica and India have each enacted a form of limited guardianship or co-decision making appointed by a court, with some obligation of the co-decision maker to respect the person's will and preferences, but it's not really clear that. I mean, one problem is that this mechanism can be appointed by a court, so it's not respecting the person's right to refuse support. It's also not entirely clear that this mechanism, the limited guardian or co-decision maker, is actually obligated to respect the person's rights, will, and preferences, and what happens if they don't. So you may be interested. The India legislation is in English, so English speakers will have no problem with that. The Costa Rica one is in Spanish. Peru is considering legislation that would abolish all guardianship and that would only allow the court to appoint a supporter in situations roughly corresponding to best interpretation of will and preferences. And I would say that would comply with the CRPD if it was interpreted in. There are some ambiguities in that legislation, but it would comply with the CRPD if interpreted in the right direction. And there's a suggestion made by the Office of the High Commissioner for Human Rights to improve the legislation to more closely reflect and adhere to the CRPD standard in the exact way that it's formulated. Remaining questions: will these reforms do away with forced psychiatry? none of none of those reforms specifically address the mental health laws. Okay, India's reform is in the Rights of Persons with Disabilities Act, which actually applies CRPD incorrectly on Article 14 and thus allows involuntary hospitalization to continue. So on Article 12, they have this limited guardianship that may be considered somewhat progressive, although the community of people with psychosocial disabilities in India was opposed to that legislation. They do not consider it progressive on Article 12, or they don't consider it to comply with Article 12. But on Article 14, it actually very clearly allows involuntary hospitalization to continue. Costa Rica's reform, actually their co-decision maker only applies to people with psychosocial and intellectual disabilities, so that's a problem to begin with. It's clearly discriminatory. But it specifies that the co-decision maker cannot give consent on a person's behalf. So that would seem to imply that there can be no involuntary hospitalization or involuntary treatment unless there's some other specific mental health law that would supersede, by virtue of being more specific, this provision in Costa Rica's new legislation. I would also say power inequalities of co-decision making and otherwise could still result in unwanted treatment. Also, it doesn't appear that there's any change to security measures relating to people being deemed criminally irresponsible. Peru's reform recognizes legal capacity for all purposes. As far as I know, Peru does not have a specific mental health law. They briefly enacted one but repealed it quickly. So it would appear that the reform in Peru would do away with any remaining basis for forced psychiatry, because people would have the right to exercise free and informed consent, to exercise their own legal capacity to refuse treatment if they don't want it, to refuse hospitalization if they don't want it. The reform does not address the criminal system, so I would imagine that declarations of incapacity to be held criminally responsible or to unfitness to plead and security measures, i.e., involuntary institutionalization in the psychiatric system, may still be applicable in Peru if it still has that. Some civil law countries also have security measures. Civil law countries being countries that have a civil code, countries whose legal system is based on the German or French models rather than the English model. Some of these countries also have security measures for people who are considered legally incompetent, who have been declared to be legally incapacitated and have a guardian appointed and are also considered dangerous. That's a separate thing. It doesn't have anything to do with being accused of a crime. It seems to be, in a sense, similar to some of our. I'm in, obviously in the U.S., I'm in a common law jurisdiction derived from the law of England, and we have commitment in psychiatry, forced hospitalization or institutionalization, based either on a supposed need for care and treatment or on the belief that the person is dangerous to themselves or others. Here, it's the dangerousness standard, but it's not in a mental health law. It's actually part of perhaps a civil code or something related to a determination that the person lacks legal capacity. and the person is considered dangerous. So I think probably such a provision, if it exists in Peru, it would not survive the legal capacity reform because you would not be able to declare a person incompetent. I have not been able to ascertain if there was such a provision and if it's part of what's being repealed. Um, and I have not been able to ascertain in relation to Costa Rica also. So those are the aspects of forced psychiatry. There's the ordinary forced hospitalization and forced treatment. There's forced hospitalization or institutionalization in psychiatry in connection with criminal charges, and there's the in some countries there's the separate thing of security measures of people considered dangerous as well as legally incapacitated that may be a separate system. So all of these are areas to pay attention to in creating reforms to do away with forced psychiatry that should be undertaken as part of a comprehensive reform on legal capacity. So we've gone a few minutes over. I have endnotes and references in the slides this time. I hope that that this has been worthwhile, and I just I don't know if two of you are still here or only one of you, but if there's any questions that you might have at this point, please go ahead and type in the chat. Otherwise, we can always address any kind of questions. What are security measures? This is something that security measures is a feature of, as I said, of some, perhaps all, or perhaps most, I don't know, but at least some civil law countries. The way I understand it, it refers to, okay, what it actually means is the person is deprived of their liberty, the person is institutionalized, and I believe it is within a psychiatric setting. So I think that it's comparable to what in common law systems, or what in the United States and maybe some others we are referring to as forensic psychiatry. So it's a kind of hybrid of prison and psychiatric institution that really seems to always combine the worst of both. And security for the general public rather than security against abuse for the person institutionalized. Yes, exactly. It's a security because it's deemed, when a person is held to be criminally irresponsible by reason of disability, by reason of so-called insanity or other equivalents, where it's considered that, well, still, even though they're actually not responsible technically in a criminal sense, even though we're not going to say we're punishing them, still we think that something needs to be done about this person. We don't want to let them out in society. They might be a danger to other people. And then it also becomes problematic. It becomes, well, if the person is not safe to be let out in society, then how are you ever going to let them out? How do you decide when to let them out, as opposed to when you've committed a crime, you're given a definite sentence. And then when your sentence is done, they have to let you out, even if they think you're dangerous, unless there's some other kind of law that allows them to do preventive detention, which is always going to be highly suspect. So yes, that's what it is, and the way that's the term that's been used. It's been used by people discussing this in the CRPD committee and around the CRPD. So I would certainly welcome if there are people in the course who have greater familiarity with it, with security measures and how they work, if they want to give us more resources. So, are there any other questions? I mentioned the supply side approach to preventing abuse in matters relating to legal capacity. What would these be? Yes, and I mentioned in one of my papers. Um, what I meant is things like laws that would penalize a person who takes advantage of another person. Say in a contract negotiation, if a person withholds information that they know would be of use, that they know would be relevant to whether the other person actually wants to accept their contract. If a person is aware, say, that the other person is actually misunderstanding something. Say, if I don't know, I'm not sure how exactly I would phrase some of these things, but what I mean is that instead of trying to create protection measures to protect the person who you're concerned will be exploited, that focus on that person. Instead, I think it's preferable to focus on measures that generally put an obligation on everybody to pay attention to and care about the mutuality of agreements and the mutuality in any exercise of legal capacity, the fairness to everybody, and not just whether you are meeting some technical requirement, but you're actually going, to get something that's good for you, but that is bad for the other person, and that if the other person knew what you knew, they would also be likely to think it's bad for themselves. That's the kind of thing that I'm thinking about, and that's in thinking about universal design. That it's better to have universal design and then specific measures targeting people with disabilities, especially when it's protectionist. Protection usually ends up being restrictive, and as Catalina de Vandas likes to say, these protection measures, these measures that are said to be protection are not protection at all. They're really anti-protection. So when I say supply side, I mean something that's going after the abuse, where the abuse exists, which is with the perpetrator of abuse and not with the victim of potential abuse. And the question, in Peru, there is no forced treatment or hospitalization except security measure. In Peru, I believe I believe there's no specific mental health law that allows forced treatments or hospitalization. They have not yet enacted their legal capacity reform. So I believe that currently in Peru, forced treatment and forced hospitalization is possible if there's a guardian appointed for a person who authorizes the hospitalization or treatment against the person's will. I think, I'm not sure if Peru, and then there would be the security measures. So I think that I believe that if Peru would enact this proposed reform, that there would be, that forced treatments and hospitalization would not be legal. And I also believe that the security measure that's only about incapacity and dangerousness would also be negated if there's no removal of legal capacity. So then the only thing that would remain is whatever security measures they may have in relation to criminal charges. But that's if the capacity reform in Peru would be enacted, which so far it has not yet been. That I think the Peruvian proposal stands as the best example of what a reform of a civil code should look like, but it has not yet been passed. How do we deal with the situation where a country has put a reservation on legal capacity? I think with any reservations, the aim is to get the country to withdraw it, or to get the country to withdraw it, but also to do whatever work you can to raise awareness and, promote legal capacity as a right, promote, the advocacy and the insistence that it is a universal fundamental right and that it needs to be recognized, that the reservation should be withdrawn, and that Article 12 should be fully implemented. I think it's worth noting Canada made a reservation on legal capacity, and in the concluding observations on Canada, I may not be able to find it now, but I will find and send to the group. The CRPD committee for the first time made reference to the fact that reservations on Article 12 are incompatible with the object and purpose of the convention. So that means that in the opinion of the CRPD committee, reservations on Article 12 are illegitimate and cannot actually be permitted as reservations. The issue is, then becomes, will the state accept the view of the CRPD committee about that? There's no mechanism by which the CRPD committee can enforce its view in that regard, or really in any other regard. It's all a matter of persuasion, legal reasoning, human rights reasoning, and authority in the sense of being mandated to review states parties reports, and under the optional protocol to review and give their views or give decisions on individual complaints. So the CRPD committee is placed in an interpretive role by the treaty that all these states parties have ratified and made legally binding on themselves, but the actual weight of the interpretation or enforceability or mandatory nature of their interpretation on states, is very much in dispute, and most would say that that these are simply not legally binding. So that's the view of the CRPD committee. It's also the view of a number of civil society experts who created a legal opinion to this regard shortly after the CRPD was adopted, after actually one state, Mexico, had made a reservation on legal capacity. They later withdrew it. You do not have to first ask the state to remove the reservation before advocating that they implement Article 12. I would say that the advocating that they remove the reservation is part of the advocacy. It's all part of the same process. You want to, convincing them to remove the reservation, I think, is part and parcel of convincing them that it's desirable and worthwhile and necessary to actually implement Article 12. So, there can always be different strategies. Mexico made a reservation on legal capacity, and then the advocacy from civil society was so strong to remove that reservation that they did remove it. They still have not actually implemented reform on Article 12, although there's various projects from NGOs and universities to create such reforms. So it's always an advocacy process. It's a hindrance if the state makes a reservation, but then as we found in many situations in the drafting and negotiation of the CRPD, there are often situations where a setback actually gives you a springboard to really come back even stronger. So there was a footnote placed on Article 12 at one point in the process saying that legal capacity only meant capacity for rights and not capacity to act in certain languages. And the fact that we had to get that removed, the fact that we had to fight to get that removed, actually drew a lot of attention to Article 12 and really placed a spotlight on it as one of the most important rights in the convention. And I think it was that was part of what led to Article 12 being the first article that was considered in a general comment by the CRPD committee. So sometimes you could use the fact that the state has made a reservation as a springboard for advocacy, as a way of saying, look, this is terrible. This is, legal capacity is so fundamental. It's about personhood, who's recognized as a person. And you could even dramatize it, say, dramatically, like show how you're being silenced and prevented from acting. There could be a lot of creative ways to approach it, but essentially, I would say it can all be part of the same process, that the state should remove the reservation and they should fully implement, they should understand, raise awareness on the CRPD model, that it's good, it's not bad, it doesn't take anything away from anybody, it's all enhancing the rights of people with disabilities and their standing in the community and all of that. So many different ways to advocate. And I see you can still, yes, in your report to the CRPD committee, absolutely report on the lack of compliance in this regard. And, if you're advocating, if you've been trying to advocate in any way, report on what the state's response has been. If you have advocated that they withdraw the reservation and they have said no, you report on that. If you're advocating they do something for implementation and they say no, we've made a reservation, you report on that. Report generally on their lack of compliance and make the point that in your view, this is something that they should withdraw the recommendation, and you want to ask the CRPD committee to ask them to withdraw the recommendation, that sort of thing. The disputed legally binding status interpretations of CRPD committee, does this also apply to general comments? Yes, unfortunately it does. The jurisprudence of the CRPD committee is not considered legally binding. What's legally binding is the treaty itself. Now the question is, what does the treaty mean? How is the treaty supposed to be interpreted? The CRPD committee is an expert body. It's created by the treaty itself. It's given the mandate to review state party reports, to comment on implementation. So they're in the best position to establish a universal standard. So human rights are supposed to be universal. If legal capacity means one thing in state A and something else in state B, the right is not universal. And so the argument goes that the CRPD committee is in the best position to establish the universal interpretation that should be considered, that should be applied everywhere. Now, some states will give great weight to the CRPD committee's general comments and other jurisprudence and even treat it as legally binding. Other states won't. And the Human Rights Committee, which monitors the International Covenant on Civil and Political Rights, has said that its views in cases under the optional protocol, that its views in individual complaints are legally binding on states. That's an instance of a treaty body essentially saying that its decisions in individual complaints are essentially the same as those of a court, that they are legally binding. But it's still certainly disputed, and there's a lot of. I think it's always going to be a question of the legal and political culture in any particular state, how they're going to deal with it. But what that really means is that has to inform certain aspects of your advocacy, certain aspects of how you approach it. It may or may not, affect the real substance to any particular degree. So, for instance, in Mexico, CRPD is officially binding, and they're supposed to be, I believe they say that they are treating, they do need to give weight. Not sure if they would say the general comment is legally binding, but the courts do feel obligated to take account of the general comment and address it, but then they misinterpret it and they apply it in a context of their domestic law in a way that subordinates the general comment to domestic law and makes it, and subverts its purpose essentially. So having it as, when a state treats it as legally binding, it's not necessarily the end of the story. There's a lot of advocacy still to be done. And even if without being legally binding, there are reasons why it should be upheld as authoritative. There are reasons why it should definitely always be considered and be given significant weight, even if it's not legally binding. So that would have to do with the way that you characterize your arguments, that the state should adhere to the standard that's in the general comment. It doesn't prevent you from using it. Okay, and thank you for those really, really excellent questions. And we've gone way over, and I'm very glad that it was in good substance. And I hope that everyone who's going to listen to the recording similarly appreciates. And thank you very much for your participation. We'll close now and look forward to all your assignments.